SJC-11222, Taylor versus Eastern Connection Operator.
All right, counsel, let's proceed.
Thank you. Good afternoon, Your Honors. I'm Shannon List-Riordan. I represent the plaintiffs in this matter. The case you have before you now is an easy case. It can be decided on based on two recent decisions of this court, the Malia case and the Feeney case. The court need not go any further than this analysis, and that is this. In the Malia case, this court addressed the enforceability of forum selection clauses. In the Feeney versus Dell case, this court addressed the enforcement of choice of law clauses. Now, in this case, we have a forum selection clause and a choice of law clause that were both drafted by the defendant employer, who is a Massachusetts corporation located and headquartered in Massachusetts. And the company decided that it wanted Massachusetts law to apply to disputes regarding its relationship with the workers, and it wanted those disputes heard in Middlesex County.
Do we have those clauses?
Yes, we do, because this case was heard on a 12b6 motion to dismiss, so everything stated in the complaint is to be accepted as true.
Do we have the text of those?
Yes, on page 8 of the record,
Okay.
the clause is quoted in the complaint. This contract and all rights and obligations of the parties shall be construed in accordance with the laws where the broker is headquartered, the broker meaning Eastern Connection, and any action shall be commenced in that jurisdiction in the closest state court. So it is here, this is a 12b6, that must be accepted as true.
Well, isn't there an issue, at least a question, whether that language is broad enough to include statutory, to reach beyond the contract to statutory causes of action?
Yes, because this language is broader than the language in the Malia case. Because in
Well,
the
I understand it is,
Yes.
but that's a question. You would agree that's a question that has to be answered in the first instance?
Yes, that is a question, and the reason why it is broader is because it says not only this contract shall be construed in accordance with the laws of Massachusetts, but it says this contract and all rights and obligations of the parties, which would include statutory claims, such as the statutory wage claim that was.
It may. I mean, I'm not. I don't. I think there's some question whether that is clear on its face, but that is the question, whether the contract language is broad enough to incorporate the Wage Act.
Well, in the forum selection clause cases, there have been distinctions made, as this court noted in Malia, between forum selection clauses that apply only to limited circumstances, for instance, a contract claim or a claim arising under the contract, or something more broad. Right. I would submit that language that says all rights and obligations of the parties is just that broader language.
But the fact that, as I sort of looked below, the language you just quoted is in the complaint. It is also quoted in the opposition to the motion to dismiss. But it's not. It's quoted. It's not discussed. It's not argued. The judge doesn't touch it.
That's right. The judge didn't touch it, although it was not waived, because on page 34 of the record, in the plaintiff's opposition to the motion to dismiss, it says, there is no question that the defendant should be cognizant of the wage and hour laws of its own state, particularly when they insert language into their own operating agreements mandating suit in Massachusetts and the applicability of Massachusetts law. That's page 34 of the record. Granted, it was not discussed at length, but it was in there, and it wasn't waived.
Yeah, and I wasn't really thinking about waiver as much. I mean, yeah, but even if one assumes not waiver, I'm just wondering whether there should be some opportunity to explore the meaning of that language.
Well, Your Honor, what we submit should have happened was that there should have been essentially a two-step process. The first step involves forum selection. could the case be brought in Massachusetts? Yes, there's personal jurisdiction over the defendant, certainly. The next question should have then been what law should apply, Massachusetts law or New York law? So we submit that if the Superior Court erred in dismissing the case out of hand, based on the forum selection clause, based on personal jurisdiction over the defendant.
It wasn't, it was subject matter jurisdiction, not personal jurisdiction.
Well, it was 12b1 and 12b6.
But 12b1 is also
Venue.
subject matter.
Subject matter. Well, so there was.
I mean, I don't think it was personal jurisdiction. It couldn't be personal jurisdiction. It was subject matter jurisdiction that the judge seemed to be going on.
Right. And given that there was this clause written by the defendant, there is nothing that violates the policy of any state not to.
I disagree with you, but
Yes.
but you do have 12b6. So then you get to this question about whether there's a stated a cause for which relief can be granted, and that gets you back to the contract language, I think.
It gets you right. It gets you back to the contract language about where this defendant, this employer, said it wanted to be sued. Were there to be a suit regarding the rights and obligations of the parties?
So if you had a contract in Massachusetts which said the rights and obligations shall be construed in accordance with the laws of Mississippi, that would govern and Massachusetts law would not apply?
Well, we would look at this court's decision in Feeney versus Dell, and the two-step analysis that this court enacted for choice of law in Feeney versus Dell is this. Where parties have specifically expressed an intent as to the governing law, we respect that intent unless the result would be contrary to our public policy. And then this court enunciated the two-step process. We inquire first whether the state chosen by the parties has a substantial relationship to the transaction, and second, whether application of the law of the chosen state would be contrary to a fundamental policy of a state, here in Massachusetts, which has a materially greater interest than the chosen state, and is the state whose law would apply. So in other words, what this court has said in Feeney versus Dell is what you do is if there is a choice of law provision, first you determine is there a substantial relationship to that state. Here, there is a substantial relationship. We have a defendant who is headquartered, based in Massachusetts, decided to hire drivers as independent contractors in a company that's headquartered and established here, so we pass the substantial relationship test. And then you go to the question about whether it would be contrary to public policy of this state or any other state to apply Massachusetts law. And here, it would not, because both Massachusetts and New York have established a public policy regarding independent contractor misclassification. Governor Patrick and the legislature of Massachusetts have established that independent contractor misclassification is harmful to workers and to the state economy.
But you don't disagree that that all goes to Massachusetts workers. Governor Patrick's interest is not in New York workers or California workers.
If you look at the language of the statutes, if you look at the language of 148, 148B, the overtime law, unlike the minimum wage law, which does on its face limit it to workers in Massachusetts, those other statutes don't. But if you also look at what Governor Cuomo has done in New York, as submitted in the amicus brief of the Greater Boston Legal Services, Governor Cuomo has likewise announced and established a policy of New York to combat independent contractor misclassification. So there's nothing that violates the public policy of New York to apply Massachusetts law.
But isn't the public policy of New York violated by having its employees within that state being governed by the laws of a different state, even if they may be similar?
No, not at all.
You're saying that if it were in Massachusetts and we said that the New York wage laws will apply, that we should apply New York wage laws to an employee in Massachusetts because those laws are similar to ours?
No. What I say is that the court would undergo this two-step analysis set forth in Feeney. As to one, here you have, remember, in this case, we have a forum selection clause and a choice of law clause that was written by the defendant. This was not imposed on the defendant. The defendant chose this. Okay? So now the defendant chose to be bound by Massachusetts law wherever it may have workers. So it doesn't offend any public policy. There is no unequal bargaining or duress or a weaker party having something imposed on it by a party of greater bargaining power. But then you have Massachusetts, if you do the second step of the Feeney analysis, the question is whether it would violate the public policy of the other state to impose this protection. So given that both New York and Massachusetts recognize misclassification of workers as independent contractors as an evil to be addressed, there's nothing that violates the public policy of New York to apply Massachusetts law. And what the court in, I believe it was in the Gagne case, recognized, in the Gagne versus Triwire case by Judge Gorton, there was a Massachusetts company and there was work that was performed in Connecticut. And Judge Gorton noted that there was no conflict in applying Massachusetts law would still vindicate Connecticut's policies because both Massachusetts and Connecticut have overtime laws. Massachusetts law is stronger. Massachusetts law has mandatory treble damages. Connecticut has discretionary double damages.
But in Gagne, you do agree that there was a connection of that employee to Massachusetts, which we don't have here.
Well, there was that's one part of the analysis. Yes, there was more connection. There was work that was done in Connecticut and there was work done in Massachusetts. But under the first step of the Feeney analysis, there is still a substantial relationship. It doesn't have to be the greatest relationship, but there's a substantial relationship, which is that, once again, you have a company headquartered here, decisions to use workers in the guise under the rubric of independent contractors were ostensibly made here. But not only that, you have the extra in this case that you don't even have in Gagne, that the company itself decided to write into its adhesion contract that it would be governed by Massachusetts law. And the company may very well have, for all we know, had reasons for doing that. It might have thought it might have been better off under Massachusetts law than under New York law because—
Surely New York wouldn't respect that.
What? I'm sorry?
If the employees brought an action in New York saying that the company is violating the independent contractor law of New York wouldn't say, well, there's a contract. The employees have agreed to be governed by Massachusetts law. Therefore, they've got no claim here. That would never happen. These are statutes enacted to protect employees. They're different from state to state in terms of minimum wage and other things. Surely the company couldn't exempt itself from New York law in this respect.
But here the point is that Massachusetts law provides even greater protection than New York law.
So, yeah, but let's get away from the choice of law situation necessarily. I take it part of your brief is arguing, well, because there's a Massachusetts employer, even if there wasn't this choice of law thing, which needs to be interpreted, Massachusetts employers, no matter where they employ their people, are governed by Massachusetts labor laws.
Well, there are—
Is it your argument or not?
That is a conclusion this court could reach based on the statutory language and based on the arguments set out more fully in the amicus brief of Greater Boston Legal Services. What I'm saying, though, is you don't have to get to that in this case. You could, but you don't have to get to that in order to resolve this case, because in this case you have something more. You have a forum selection and choice of law provision written by the defendant. In some cases, the something more might be especially close contacts between Massachusetts and the work. Or it could be, as in the Dow versus Casale case, where you have an employee in Florida who works in multiple states, and there's the impracticality of imposing the laws of all those different states. The court could reach the broader question of whether the plain language of these statutes, of these wage statutes, other than the minimum wage law, does encompass work done outside Massachusetts simply because there is no limiting language on 148, 148B, or the overtime law like there is on the minimum wage law. Or the court could look at the fact that, as the functional approach that this court takes on choice of law analysis, which is you look at what you have. In this case, we have forum selection and a choice of law provision written by the defendant. In other cases, you may have some of the work done in Massachusetts. In other cases, you may have more of the direct supervision done from Massachusetts. The court doesn't have to reach that big overarching question about whether any Massachusetts employer is going to be bound by Massachusetts wage laws for work performed by its employees anywhere in the absence of some of these other factors. You could reach that, but you don't have to here.
I guess the question I have is, why can't we say, okay, so Massachusetts law will apply, but under Massachusetts law, we look to the state of employment, and we apply, under our Massachusetts choice of law principles, we will apply the law that governs the state of employment. And therefore, under Massachusetts law, we will look to New York law, but there's been no claim under New York law. So arguably, if there was a claim here saying the violation of the New York law, arguably we would then apply it and apply New York law to that. But you've only claimed a violation of Massachusetts of the Wage Act, and that has to be dismissed because under our choice of law, we say it's the state of employment which governs.
Well, because, Your Honor, here the choice of law provision that this defendant wrote said that the rights and obligations of the parties shall be construed in accordance with the laws where the broker is headquartered. So in other words, not the choice of law will be looked at based on whatever the choice of law provision is of where the broker is headquartered. It's that the rights and obligations shall be construed in accordance with the laws of Massachusetts. And under Feeney versus Dell, this court said that parties' choice of what law will apply will be respected absent some result that would be contrary to public policy. And the type of public policy that this court said it would look at is, for instance, if a company wrote a choice of law provision that Texas law would apply, but you, for instance, if you couldn't sue for independent contractor misclassification in Texas, or you couldn't obtain any type of damages or something that would prevent you from having your rights enforced in any way, shape, or form, this court would not allow it. But here, where a sophisticated party wrote specifically into its contract that Massachusetts law would apply with respect to all the rights and obligations of the parties, there is no reason for this court to deviate from that. The mere fact, just like in the Ganyu case, where Connecticut law, like Massachusetts law, both protect against overtime deprivation, the mere fact that Massachusetts law has a stronger remedy, mandatory treble damages as opposed to discretionary double damages.
I have to wind up now. Your time is over.
Thank you.
Thank you.
May it please the Court, Mr. Justice Ireland and the other justices. My name is Robert Berluti. I represent Eastern Connection, Operating Inc. in this case, and I submit that the decision of the lower court should be affirmed. This case is about subject matter jurisdiction.
How can it be about subject matter jurisdiction, though? You've got a defendant who clearly is here. It's an employment dispute between the defendant and people who claim to be employees, they claim are independent contractors. That's within the subject matter jurisdiction of the Massachusetts courts.
Respectfully, I don't think so, Your Honor. What the allegations are that these are New York residents performing all of their work in New York, reporting to New York managers, Your Honor. The only connection
They're employed by a company that is here.
That's headquartered here.
Right.
But everything about the employment is in New York, Your Honor.
They may have failed to state a claim, but I just don't see where you get subject matter jurisdiction.
Well, respectfully, Your Honor, I don't think the Massachusetts courts have sufficient contacts for purposes of applying the Massachusetts wage and hour laws. There are only 3 claims
It goes to
made.
the claim. It doesn't go to whether there's sufficient context to entertain the parties, is it?
Well, I think the statutes on which this plaintiff has sued specifically goes to the conduct of the employees, not to the existence of where the employer is headquartered. The independent contractor statute focuses on what the employee does, what their relationship is to the employer, and whatnot. So respectfully, I think that subject matter jurisdiction is an issue.
Does it matter at all that the alleged illegal conduct, which is certain non-payments, occurred in Massachusetts? Wasn't the decision-making going on in Massachusetts?
There's no evidence of that in the record, Your Honor. All of the management, and in fact, I think the reasonable inferences are that the negotiations of this contract are in New York. There's no evidence that somehow this contract is used uniformly throughout the company. So the only inferences to be drawn from this complaint is that all decisions were made in New York.
Except for this contract forum selection and law clause, which surely suggests that a Massachusetts employer has a significant interest in this. I mean, they've drafted this agreement which says Massachusetts law shall apply.
Well, interestingly, Judge, first of all we have is one sentence. It's cited in the complaint under venue, not under a fact alleged. And I would submit to you that if you read the contract, these words don't exist, but I think what it implies is the following. This contract and all rights and obligations of the parties under this contract, I think, shall be construed in accordance with the laws of the broker, et cetera. So I don't think it's as broad as the plaintiffs are making it sound to be. In any event, it is not broad enough to implicate the Massachusetts statute.
I might agree with you if it said that. It doesn't say that. So how do we go back and?
Because you don't have the contract in front of you. You don't have the entire contract.
Oh,
here.
we have.
You have one sentence.
You didn't submit the contract. You didn't. We have the sentence of the contract that the party says governs. It seems to govern. Talks about the.
It talks about it, but you don't have the whole context, Your Honor. Moreover, Your Honor, I think it's more significant that there's no breach of contract claim here, and perhaps most significant, what the plaintiffs are really arguing is that this contract is void as a matter of Massachusetts public policy. They are citing this one sentence for venue purposes, but what they're then saying is that under Massachusetts law, given all the other factors alleged in the complaint, the contract is void as a matter of public policy. And I think Justice Gantz was right. If you look at this contract and you apply the New York law based upon the Massachusetts choice of laws, you might reach a very different conclusion for the following reasons. The New York Joint Task Force publication is attached to the amicus brief filed on behalf of the plaintiffs. And that indicates that New York's public policy is twofold. As to the construction industry, they apply an ABC test identical or it's very similar to the Massachusetts independent contractor test. But as to all other industries, they apply the common law test, and that it's in their interest, given their economic situation, to have a different viewpoint on the relationship between independent contractors and people they contract with. It's not the same. And so if they want to have a less stringent approach and promote more independent contractor activity as they see it, they should be permitted to do so. And I think that there are a number of differences and practical problems that have been raised here, not just minimum wage, but also what are the rights under workers' compensation? Where does unemployment insurance get paid? If these workers apply for...
What is this language supposed to mean if it doesn't cover things like that? I mean, your clients drafted this language. All rights and obligations of the parties shall be construed in accordance with Massachusetts law.
Not as to the statutes, Your Honor. It's as it applies to the contract, but not as it applies to the statutory law. If one of these employees wanted to apply for unemployment insurance, they would surely have to apply in New York. Their withholding is made in New York. It's not made to the state of Massachusetts. This form selection clause can't be read to totally vitiate New York law, where all of the contacts are in New York. Moreover, I go back to the point that they are relying, the plaintiff's case relies upon this one sentence of this agreement that's not before the court. Yet, they are arguing that this contract is void as a matter of Massachusetts public policy.
Well,
and
are they really saying it's void, or just that they're saying they should be treated as independent, as employees?
Well, no, they're saying that there would be void because the terms of the contract would not be adhered to. The terms of the contract would not apply. So they're saying that it's void as a matter of public policy. And that based upon what the activity is, if you use the Massachusetts analysis, you'd reach a conclusion that they were independent contractors. And I submit to you that if you were to apply the New York common law test, that conclusion could be very different. But
we don't know what the contract looks like, but you could certainly conceive of a contract that we would still uphold with respect to other elements of duration and things like that. And so their only focus is those elements which speak to their status as independent or not.
You would go through the
Maybe the
analysis.
same
common-
stuff. It's just what flows from their status is what's.
That's exactly what I'm saying. It flows from the status, from the actual activity, and it's a fact-based analysis. It's not, in which the contract could be viewed very differently, the existence of the contract and the agreement under the common law test as opposed to an ABC test that by its own terms, the Massachusetts statute by its own terms throws out contracts and to say that it's to be disregarded.
This is aside from that, but when the judge says in his opinion that the plaintiffs have acknowledged that they're independent contractors, this was a motion to dismiss. What's the evidence of that? Is it just based on the fact that it's alleged that in the agreements they're named as independent contractors?
That's what I'm taking from it, yes. That from the plaintiff's allegations in their own complaint that they are termed under the contract to be independent contractors.
If they had brought the same claim under New York law, would you claim that there's no subject matter jurisdiction?
I think no subject matter jurisdiction of the Massachusetts courts.
Yeah.
I think that one might be different because I think that one may be different. But I don't think that there's subject matter jurisdiction in the Massachusetts courts for this activity. You cannot confer subject matter jurisdiction by way of agreement, consent, or waiver. So I don't think subject matter jurisdiction would exist in any event.
And there's no waiver of that when you say it shall be commenced in that jurisdiction, requiring under the contract that claims be brought in Massachusetts? So
I think as
basically you can include that, and then when the employee or independent contractor follows that provision and actually commences it in Massachusetts, you can then say to be dismissed for lack of subject matter jurisdiction?
I think personal jurisdiction is something that the parties can agree to and can contract on. I think as to subject matter jurisdiction, it's different. I do not think that as a matter of law that it's axiomatic, that you cannot confer subject matter jurisdiction by way of agreement, consent, or waiver. We've cited a case to that, and we've cited cases to that in our brief. It's the Clapp decision, I believe. So what you're left with is their position rests upon a contract which they ultimately decide, which they ultimately are saying is void and is not enforceable. So if you don't have the contract and you apply the other choice of law type analysis, it's New York that has the greater interest in the result here. And it's New York that it's New York laws, New York's analysis of whether or not they are independent contractors, New York's law as to whether or not they're, overtime, they're entitled to overtime, and what rate of overtime is to be paid, and what amounts can or can't be withdrawn from their paychecks that have the more substantial relationship to this dispute than does Massachusetts, and certainly not the Massachusetts statute.
But the problem I have with that is that if they had brought this claim somewhere else, saying the contract is void, you'd still be invoking this provision and say, no, it must be commenced in Massachusetts.
Well, Your Honor, even if they bring it in Massachusetts, but as Your Honor has said, New York law were to be applied, the complaint would still be dismissed because they've alleged no New York law violations. They have not even alleged a breach of contract violation. They've alleged only Massachusetts statutory violations. So to get there, this court would have to be permitting extraterritorial application of the Massachusetts statutes.
So are you saying that if this case were brought in New York, a New York court couldn't disagree with you and say, no, we're going to apply Massachusetts law here?
Well, they would go through their own analysis, choice of law.
But they could apply Massachusetts law here.
They would go through their own analysis. And I think that under their analysis, the functional analysis that it was outlined in the Amelia case, it's unlikely they would reach that conclusion given
but
which
they could conclude that Massachusetts law should be applied to these people.
Well, I respectfully submit that based upon the activities that take place, the residents, all of the work that's performed, the decisions made, that it's New York that has the more substantial interest, and it's the New York law with respect to these statutory causes of action that would apply. There's no, New York has all the same public policy type laws. Unemployment, overtime, workers' compensation, all the things that the concern about when you misclassify employees. New York even has a joint task force that's attached to the amicus brief for the plaintiffs. So they have all of these same protections, but in the way that the New York legislature wants to enforce them. And if there is a difference in the way New York wants to apply it, that's the law that should apply. Now, one of the...
Let me ask you a hypothetical just to follow up on that.
Sure,
I'm not
Justice
trying to pick on Texas, but since that was used before, and I don't even know what the law of Texas is. What if this had said law of Texas or X, and that had no protections similar to the ones you're talking about in New York? Would you still be making an argument here about subject matter jurisdiction?
I think subject matter jurisdiction has to take place in the forum that has at least minimum contacts, sufficient contacts with the dispute. And certainly in this instance, Texas would have no contacts with it. So I think that you would not be applying a Texas law to this situation. And I don't think the plaintiffs would be seeking it. I don't think it would be enforceable.
You would, what if they were there? What if this is a broker? It anticipates, let's say, having employees all over the country. So in every state that your client now needs to litigate these questions, you'd be making a different argument?
No, I don't think so. Again, you're dealing with statutory claims. So, perhaps an easy example would be that of a non-compete agreement. If this employer were to hire somebody in California and say there's going to be a non-compete agreement, but Massachusetts law is going to apply, does that mean that even though California does not recognize non-compete agreements, that the non-compete in this contract would apply? It can't be. It couldn't be that result. I think that the law of California, if the person were a California employee, would be the one that applies no matter what the party's contracted to, because that's the jurisdiction that has the greatest context, the greatest contact with the dispute. So I think that if you go through all of the cases in which Massachusetts law has been, statutory law has been applied extraterritorially, has been one of two situations. It's either been where a Massachusetts resident performed the work outside the jurisdiction, or with someone who is outside the jurisdiction performed work in Massachusetts. There's no instance in which there's been any case in which an outside resident performed the work outside and had the Massachusetts statutory laws apply. So if there's no other questions, for the reasons stated, I would respectfully ask the court that the lower court decision be affirmed and that this complaint be dismissed.
Thank you.